And welcome back to Facts or Frauds. Make sure you hit the thumbs up button, you're subscribed, and ring that bell for notifications so the next time I premiere a video you can be in the live chat with everyone else. And leave a comment in the comment section, tell me what you think. And it's a Rise of the Moors court update.
This was part of the oral argument for something I filed to dismiss the accusatory instrument based on a failure to state a claim upon which relief may be granted. I had wrote that or a portion of the argument before the United States Supreme Court had made the Bruin decision. So once the United States Supreme Court made the Bruin decision, I added it to my argument. So I started off the argument with reference to the my argument was 60 pages in total. I think it was a little more than 60 pages, but I'm pretty sure it was 60 pages. I had hand wrote it in jail while I was in the cell. I was in C-Pod, cell 228.
Dear moron, am having a swell time here at the insane asylum.
And I wrote it handwritten. And in Massachusetts, there's Massachusetts case law, which is cited in my argument. So this is from Massachusetts Superior Court itself, or it might be from the Supreme Judicial Court of Massachusetts. I can't remember, but it's in my argument, which you can just call the clerk and ask for it. It's public information. There's a Massachusetts case which specifies that the courts of Massachusetts treat statutory exemptions as an affirmative defense. There's additional case law from the courts of Massachusetts that specifies an affirmative defense, or when an accusatory instrument raises upon its face the existence of an affirmative defense, then the argument fails to make a claim upon which relief may be granted, right? And obviously, when this fails to make a claim upon which relief may be granted, the case gets dismissed. In this argument, the judge had brought up the issue that, and he didn't specifically say that it only applies to civil issues, but he insinuated it without saying it. He made the argument of it only applies to civil arguments, but that's not what the courts of Massachusetts said. There's no case law that specifies that it only applies to civil actions. An example of that, and specifically a statutory exemption, which is an affirmative defense, and how the issue must be dismissed is, as an example, if an individual is charged with the unlicensed possession of a firearm, and in the statute it says that, you can't be charged with unlicensed possession of a firearm if you have a license to possess the firearm, then the individual who has a license would raise the argument that, well, I have statutory exemption because there's a statute that says I'm exempt, here's the license, and then the case would be dismissed administratively because the prosecutor would say, basically they would fail to make a claim upon which relief may be granted because they can't prove that the individual doesn't have the license because they're statutorily exempt.
Are you a bonehead?
Likewise, and that would be dismissed, so that issue wouldn't go to trial because there's a statutory exemption, and statutory exemptions are treated as an affirmative defense, and affirmative defenses are, in essence, failure to make a claim upon which relief may be granted. So you'll see in my 60-page argument where I had argued within the Massachusetts statutes the clause where it's completely legal for an individual to hold, handle, and even fire a firearm without a license for lawful purposes. And since the Second Amendment exists, exercising your right to bear arms in the name of self-defense and in the name of self-preservation, especially as a militia, so not only individually to keep and bear arms for self-preservation and self-defense, but also as a militia, so it protects us as an individual and in the status of a militia, that is a lawful purpose. And since it is a lawful purpose, there's a failure to make a claim upon which relief may be granted based on that statutory exemption. There's another separate statutory exemption that exempts militias in general. which, according to Title 33, and this is all within my argument, I cited this, Title 33 of the Massachusetts statute, it clearly recognizes the organized militia, which would be the Marines, the Army, the Navy, the Coast Guard, the Air Force, and the unorganized militia, which would be the people, which would be, as an example, the Moorish militia. And there's a third clause within the statute that exempts individuals who are traveling through the Commonwealth without making any unnecessary stops, which is pursuant to the federal laws of the peaceful journey. So I cited all three of those statutory exemptions as our affirmative defense, which would mean there's a failure to make a claim upon which relief may be granted, which would mean this case has to be dismissed.
Hey, it's Arty of Arty's Corporate Fiction. So Jamal is trying his best to shoehorn an affirmative defense, but still couch it as what is effectively a civil motion to dismiss, which is failure to state a claim upon which relief can be granted. And the way he tries to do this is you have to accept a whole bunch of false premises here. Essentially, what Jamal is trying to argue is that because his militia exists, and I guess the Second Amendment affords the ability of state to raise militias and regulate militias, his militia requires the use of a firearm for the provisions of self-defense. Ergo, he doesn't need a license to carry a firearm. Ergo, he's statutorily exempt from the Massachusetts license to carry statute, which doesn't make any sense. And he's also trying to couch it as an affirmative defense, even though it's not even an affirmative defense under Massachusetts state law. The state would have to prove that he would have to show that he is not obligated to have a license to carry, but he hasn't figured that out yet. He hasn't solved that yet.
So that was also, or added to that, was when the Bruin decision came down from the United States Supreme Court, saying that, you know, as an example, the Second Amendment is not a second-class right subject to completely different laws. You know, I brought up the issue of no other right is subject to licensing. You don't need a license to exercise your right to free speech. You don't need a license to exercise your right to a trial by jury. You don't need a license to exercise your right to due process of law. You don't need a license to exercise your right to be secure in your person, papers, or effects. So if the United States Supreme Court said the Second Amendment is not subject to entirely separate laws, well, then that means it can't be subject to licensing. Likewise, I brought up the Murdoch versus Pennsylvania, which specified that a constitutional right cannot be taxed or licensed. When we look up the definition of license tax, you'll see that you know, license tax is for public safety, and when they apply the licensing scheme, they do it in the name of quote-unquote public safety. So that in and of itself is a license tax and unconstitutional. Additionally, the United States Supreme Court, which the Asiatic judge did the majority decision, specified that when the plain text of the Second Amendment protects an individual's conduct, then that conduct is protected, which means you can't be charged with a crime for conducting yourself according to the amendment. The word militia is literally in the amendment. Not only that, but it was stated that judges have to go into the history of the Second Amendment, and you'll see where I addressed that. I don't know. I'm not sure if I posted it, but I addressed it in the argument, specifying that I don't think I posted it actually. No, I didn't post it, but it's in the transcript. That and this isn't my historical finding. This is the findings that the United States Supreme Court referenced because they brought up Young versus Hawaii, which I also brought it up. And in the Young versus Hawaii case, it talks about how the origin of licensing. So this is the origin of licensing. So when seeing if a statute is unconstitutional, you have to look at its origin. You have to look at the history of the amendment. You have to look up the history of the enforcement of the amendment, and you have to look up the history of the regulation of the amendment. The origin of licensing applied to slaves. So all they're doing is applying slave laws, and that's unconstitutional. Not only that, but during the grand jury minutes, a juror asked the prosecutor, "So how does this militia thing work?" And he didn't give an answer. He said, well, normally, he said generally, I'm paraphrasing, I believe. He said generally, a militia is attached to a state. There was already, and I provided information from the federal courts that states that that's not true. That's also listed on my website as well. If you go to Res Judicata, you go to Second Amendment, and you'll see, if you read all of it, you'll see where I reference the federal courts where they, it was the District of Columbia saying that a militia only exists if it's subject to state regulation, and then the federal court said that is too narrow of a claim. So if the federal courts are saying that, and that was revealed in the federal courts, then clearly that's not the case. So the jurist asked how does the militia thing works. The prosecutor deliberately withheld information, and that was part of my argument. And you'll see right here, Mr. Abdullah is obviously me. As far as the militia, when it wasn't asked if I, as an individual, was in a militia, because the prosecutor had made the claim that, I individually, but that's not what the juror asked. He didn't ask if Jamal Talib Abdullah Bey was in the militia. He asked generally, how does the militia work? Right? And the prosecutor deliberately withheld this information regarding the United States Code, where it specifies that proper age for militia service is 17 years old.
Again, so my problem with Jamal making this argument about his involvement in a militia, the militias are governed by the states. His rise of the Moors militia is not a recognized militia according to the state of Rhode Island or the state of Massachusetts. Nobody. It's his own paramilitary LARPing group. So he's not a militia. He can't cite to the U.S. code and say, oh, here we go. Here are the rule, regulations, and regulatory bodies about the militia. You're not a militia. You're not your LARP group is not a recognized or valid or authorized militia. Your entire argument falls apart right there.
So anyway, when the juror asked, how does this militia thing work? He should have brought up as an example, as part of his duty to provide full disclosure to the jurors. He should have said, as an example, in the United States Code, 17 years of age is proper for militia service. So if that information was given, then, just as an example, bare minimum, I wouldn't have been charged with improper storage of a firearm where a minor had access, because that 17-year-old, quote-unquote, minor is fit for militia service according to United States federal law, which means he's not a minor.
Wait a minute. Whoa.
Not only is he of the age requirement at the time, but he was actually in a militia. So if that's the case, and the juror knew that, then he or she or them or they could have concluded, okay, well, maybe we don't want to indict on this specific charge. And who knows, what else that would have applied to. It could have led to me not being indicted at all, which is exactly why the information was withheld. And you see that in my argument right here, just as an example. So if this juror or panel of jurists was informed of this, which they did not know, then there's a high probability that none of us would have been indicted with these charges if they knew the law. And then again, with the Bruin decision, the United States Supreme Court struck down the two-prong test, which if you get this oral argument, you'll see where the prosecutor was using that two-prong test or relying on case law, where the prosecutors and the judges relied on the two-prong test to justify the Massachusetts licensing scheme. The Supreme Court of the United States struck that down, so they can no longer rely on those cases to justify the licensing scheme of the Commonwealth of Massachusetts.
It is incompetent, irrelevant, and immaterial. Or something.
And that's within the decision itself. In fact, before it even went into the unconstitutionality of the New York statute and the Massachusetts statute, it addressed that very thing. And then again in 2016, the United States Supreme Court addressed the dangerous misuse of the Heller decision by the Massachusetts courts. I believe it was Commonwealth versus there was a female who purchased a taser to defend herself from her abusive boyfriend. They basically found her guilty of a crime and threw her in jail. Like, oh, just get beat up by your boyfriend. Don't use a taser. That's a dangerous weapon. So, you know, it's proof that it's dangerous. And of course I use that and I reference that, and I believe that's on the website as well. But this is for you to read. A decision still hasn't been made on this. It's been, I think, when did I make this argument? December? November? It was before that. It was October, wasn't it?
Before that.
It was before October? Mm-hmm. Oh yeah, was it August?
This was the
Bruin
suppression?
one. No, this was the Bruin decision.
Oh, no, that might have been October, November.
So since October, this decision still hasn't been made. He said he's going to take it under advisement. The decision still hasn't been made. And in the case, in the beginning of the case, you'll see where even this judge talks about how every single state is looking at their licensing scheme to ensure that it doesn't conflict with Bruin. So this isn't a small thing. This is affecting every single state of the union. And then, of course, I brought up the fact that there are several states within the United States that have what is referred to as constitutional carry states or permitless carry states. And they base that on the fact that the Constitution already grants the right, so there's no permission needed to exercise that right. So if there's no permission needed to exercise it in those, and I believe it's at least 25 states, so half of the union, what does that say about the other half?
Jamal's now starts to argue that, well, other states have constitutional carry laws. Well, effectively saying that you don't need a license anymore to carry in these particular states, or they're very, very, very lightly regulated. But Massachusetts doesn't have that. Massachusetts still has its existing carry licensing apparatus in place, even after the Bruin decision. And as far as I understand it, the Bruin decision did not invalidate Massachusetts carry license law. Bruin did not completely wipe away all forms of licensing when it comes to open or concealed carry. It only struck down laws, carry laws, or effectively certain laws that would effectively create a de facto ban on concealed carrying. So states, for example, states like New Jersey. But if Massachusetts isn't one of those laws, then it still would effectively be valid on the books. So his argument, again, completely falls flat. It doesn't matter whether or not there are other states that have constitutional carry licensing, constitutional carry. What matters is what Massachusetts has. So until he can make that claim that existing Massachusetts law is contrary to the Bruin decision, it doesn't matter. Even still, I don't know if he can really even do it effectively. He doesn't really have much of a case here. So I'm actually very curious to see what the judge is going to rule on in his motion.
Why aren't you doing that? And then again, they'll say, well, public safety. And that was my argument in my decision. If you're worried about public safety, criminals don't go to gun stores and go through background checks. So this only applies to law-abiding citizens. It doesn't apply to criminals. So you're only affecting law-abiding citizens. And not one time has the prosecutor alleged that my firearms were purchased illegally, because any firearm that I've ever purchased in my life, I first passed a state and federal background check to own it. So clearly I'm not a criminal in possession of a firearm. So as far as public safety is concerned, there's no worry about that with me, because I already passed the state and federal background check.
2 Rise of the Moors members currently being held in Massachusetts are wanted on new charges in Rhode Island.
There is a record appendix that has photographs and, with respect to Mr. Cumberlander, information about charges pending against him in Rhode Island.
Quinn Cumberlander and Jamal Latimer were arrested July 3rd after an hours-long armed standoff with state police on I-95 in Wakefield. Tuesday, Attorney General Peter Nerona announced they are wanted on firearms and bail violation charges. Cumberlander is alleged to have provided a false address during multiple attempts to buy a gun from a dealer in Warwick. The AG's office says Latimer violated terms of his bail out of Providence Superior Court. According to the release, Bay was arrested in March 2020 by Rhode Island State Police.
Well, there goes your excuse there, Jamal. And now for your trial dates. Let's get to it. Jamal Tavon Sanders Latimer, we'll see you on trial May 22nd, 2023. Quinn Cumberlander, August 7th, 2023. Huh? Aaron Johnson, May 22nd, 2023. Aban El Kara, May 22nd, 2023. Lamar Dow, May 22nd, 2023. Connell Pierre, May 22nd, 2023. Omar Malik Antonio, May 22nd, 2023. Wilfredo Hernandez. Now here's some news on Wilfredo. He took a plea deal. Yes, he listened to his lawyer and took the plea deal. Got 7 years in the state penitentiary and 3 years probation. How's that, huh? Yeah, you wish you would have all listened to your attorneys now. Robert Rodriguez, we'll see you in trial March 21st. Latoya Johnson, March 15th. And my many special thanks to Arty from Arty's Corporate Fiction. If you're not subscribed already, go on over to his channel, check him out, and give him a subscribe.
You can't fix stupid.
And thanks for joining us on Facts or Frauds. Make sure you hit the thumbs up button, you're subscribed, and ring that bell for notifications so the next time I premiere a video, you can meet a live chat with everyone else and leave a comment in the comment section. Tell me what you think. And a huge thank you to our channel members, Robert Morley, Bandon, A&D, Chris Kelling, Goddess of Truth, Pedro, Grendel S. Rage, ArchAnglAzreal, Shawn, OldFart, Pat's Cats, Drew B, Colt Stonewolf, CW1960, and Butcherbird. Wanìshi. Thank you. If you'd like to become a member, just hit that join button right next to subscribe or click on the link in the description. Now, if you're still hanging around, why not hit that subscribe button? Yeah, you might like it. Hit the thumbs up, and if you'd like to support the channel, hit the thanks button. Until next time, wanìshi. Thank you. I'll see you soon.